Hello viewers, welcome to Access to Justice module, and our discussion is going to be on informal access to justice. The name itself is quite interesting, because when we talk about informal thing, that means it does not have any regular authorities to regulate it, or it may be that there is no exact procedure to be followed, or maybe it is a process where the enforceability would be an issue. So, keeping these things in the background, I am going to take up a discussion on informal access to justice. When we talk about informal access to justice, means there is an access to justice which is formalized, which is a formal one, that is courts, a judicial setup. When we talk about informal access to justice, we are talking about something else other than the court process. The question is, why we are talking about informal access to justice? Is it because our formal justice is defective, or is it because the defects of formal justice are such that that cannot be rectified, or is it that certain kind of dispute shall or should pass through this informal process? My request is that do not encourage this informal process because you find fault with formal system, but you encourage this informal system because you find it advantageous for certain kinds of disputes. Informal access to justice is popularly known as ADRS, Alternative Dispute Resolution Systems, and there are two modules which deal with this informal justice system. Today's module is going to be on negotiation and mediation. Myself, Dr. B.S. Patil, assistant professor working at V.M. Sargaonkar College of Law, Goa, and my discussion would be on negotiation and mediation as informal access to justice. To start with, let me impress upon the equal justice to all. Is it a reality, or is it just a fake promise made? Equal justice for all. When you go to court, do you think that both parties are put at equal footing, so that the parties are heard with equal detachment, and then finally there is a decision on the court where the court treats both parties equally? My answer is no, because when you talk about equal justice for all, we are talking about presentation of case by a lawyer or an advocate who are equally competent. Take an example of a person with very well off and with a lot of resources available. You would employ the best lawyer in the town, and best lawyer in the town provides best service possible in the town. With best service possible in the town, he is going to provide or present the case in a best possible way and tilt the law in his favor with his pure acumen on law. Therefore, equal justice for all may not be true all the time. This is only one part of the problems that we are facing. The other part of the problem is courts are having series of problems like unpredictability. Same set of facts, same cause of action, same parties, we get different verdicts. Trial court says plaintiff is entitled, appellate court, first appellate court says defendant is not liable, second appellate court says plaintiff is again entitled, but not the same amount, different amount, different orders. Why there are different verdicts on same set of facts? It is because of unpredictability of the court proceedings. Expensive, surely. Court proceedings are really expensive, because not only that the court fees, advocates fees are exorbitant, in addition to that the cost of litigation multiplies as you are made to visit the district headquarters frequently, and the transportation cost, the time hours of work that have been lost, the labor that has been lost, if you add up all of them, it would be a very expensive process. Political interference, I do not think it is a major problem, because judiciary has insulated itself from exterior influence, but definitely it is one of the issue to be looked into. Interestingly, the major problem is technicality. When you talk about technicality, the court supposed to follow the procedure, and if there is a fault in following of the procedure, the decision would be set aside. To follow the procedure, too technical, too much of delay, and the technicality definitely going to lead to another issues relating to expertise. Judge is technically competent in procedural law, that is CPC, but is he technically competent to deal with the specialized nature of the dispute? Take an example of a dispute relating to designs, dispute relating to copyright, simple dispute relating to construction. He has to understand the terminologies used in that construction business. He has to understand the kind of materials that are used, the kind of language they used when they measure the construction area, constructed area. He has to understand the technical meaning of each word spoken, and mostly they speak in abbreviations like most of the lawyers do. So, how to handle these, the lack of expertise? What happens is, when a judge is not expert in that area, he spends more time in understanding the nature of business, causing delay. What I have done now is I have picked up unpredictability, uncertainty, political interference, but what I have left out is one vicious cycle. The cycle, the final result is delay. Why there is a delay? Because there is backlog, because there is too much of technicality, because there is too much of uncertainty, because of lack of expertise. See, delay and backlog are interchangeable. The more the delay, the more the backlog. The more the backlog, there would be more delay. So, delay and technicality are again correlated. Too much of technicality, too much of delay, and too much of delay, too much of backlog. So, therefore, all are interconnected, and to address these problems, we need not address each one separately. Once one problem is addressed, whereas they are interconnected, all could be solved simultaneously. But I am not standing here to provide solution to these problems. I am here to talk about an entirely different proceedings other than these court proceedings, that is informal justice system. So, anciently we had two systems. I am not big fan of both the systems, because they were not appreciated because of influences they were undertaking, the social influences that they were exerted on these systems. One was situation specific system. A matter comes up before the leaders of the village decide based on the situation and based on the requirements. But there is another system which is more suitable, that is interest based justice system, where the dispute, when brought before the village heads, the village leaders, they look into the interest of both the parties and decide in such a way that the interest of both the parties are protected. So, when the interest of both the parties are protected, we are ensuring the adherence to the decision. They accept it and they love the outcome of the proceedings. So, this interest based system is being developed further into informal system. So, when we talk about informal system, we are talking about four systems, that is also known as four methods of ADRS, alternative dispute resolution systems. Negotiation is one such thing, which is the primary process, and here the two persons sit across the table, discuss, talk and solve the dispute. I do not think it would be as easy as I mentioned, but this is how the procedure goes on, and with lot of hiccups in between, deadlocks in between. Mediation, again same thing, there is two parties sitting across the table, discussing the matter, but interestingly in presence of a third party called a mediator. And what this third man is doing when two parties are discussing their problems, this third person is intervening at necessary point of time, ensuring meaningful discussion among the parties. Conciliation is the third ADRS, which is similar to mediation, where two parties are talking, discussing their problem in presence of the third person, who is again playing similar role like mediator, intervening with the parties, encouraging the parties to go for discussion, facilitating the parties to come up with a proper outcome. Arbitration, it is the most advanced ADRS, where the parties are presenting their case. There is again parties sitting across the table, but they are not talking to each other, they are not discussing between each other, but they are presenting the case to this third person, who is a private judge, and this private judge would pronounce a binding order, a judgment which is called as the award against both the parties, and the parties have to obey the orders of the arbitrator. So, the difference between arbitration and other ADRS is that the parties do not have the freedom to walk out of the proceedings, parties do not have the freedom to refuse the instructions of the arbitrator, but whereas parties can refuse to listen to mediator and conciliator, because they hold the complete control over the process. So, with this brief background of the ADRS, let me take up under today's discussion the two aspects of ADRS or informal justice system, that is negotiation and mediation. And in my discussion I am going to talk about negotiation, process of negotiation, and the requirements, qualities of a good negotiator, and brief discussion on law relating to negotiation, and similar procedure I will follow for mediation.